Welcome back to City Education, your home for knowledge in all forms, shapes, and sizes. Today we continue on unlawful competition. This time around, we are focusing on common law prohibitions. Common law identifies several types of prohibited conduct that fall under unlawful competition. These include, firstly, passing off. This is the most well-known form of unlawful competition, occurring when a person represents their business, goods, or services as being that of another business or being associated with that business. In order to determine that passing off has occurred, it says if there is a reasonable likelihood that the public will be confused into believing that two businesses are the same or connected. For example, some tuck shops in the Palestinian community have been found to be making their own version of Coca-Cola soft drink and using the very same packaging and bottles with the very same color, intending to mislead the public.
The second principle or second
prohibition is leaning on. This occurs when a business uses the advertising value and thoughts of another to promote their own products or goodwill. It doesn't require confusion about the origin of the goods, but rather a misrepresentation of goodwill and reputation. For example, Kanga fried chicken. It is leaning on Kentucky Fried Chicken
to sell as a product.
The conduct is considered contra bonos moris, against good morals, because a competitor is trying to attract customers based on another's merit, not their own. No, 3, we have misappropriation, and this
Use of trade secrets.
It is common knowledge that a person who obtains confidential information is not allowed to use it in any way that is detrimental to the person who shared it. Now here, the information must have quality of confidence about it and not be public knowledge. The defendant should not benefit from their own wrongful act of appropriating confidential information. For example, the secret formula of Coca-Cola is tightly guarded. Someone decided to sell it, and it led to someone else starting a similar, tasty drink. That would be considered misappropriation and misuse of trade secrets. No, 4, we have misrepresentation as to geographical origin. Here, it is important to note that it is unlawful to misrepresent the geographical origin of goods. This can deceive potential buyers into thinking that the product was manufactured into a different or from a different country than where it was originally manufactured from. For example, someone creates a clothing brand using the color green, white, and red, then claims that such a brand is straight from Italy. That would be considered misrepresentation as to the geographical origin. No, 5, we have misrepresentation as a nature or composition. This happens when a trader uses the known name of a product but slightly changes the recipe or contents, all while keeping the original name. The goal is to ride the custom wave of the original trader who has built a reputation and invested in marketing in their product. No, 6, we have misrepresentation as to class or quality of goods. This involves misrepresenting a class or quality of a product, even without misrepresenting its origin. For example, calling a pearl wine a sparkling wine, as the latter is generally considered more luxurious and expensive. This also includes selling second-hand goods as new. Number 7, misrepresentation that another trader's goods are your own. Now, this occurs when a trader removes another trader's labels or packaging and replaces them with their own, then sells the product as their own. Moving on, we have dishonest adoption of a competitor's sign or get up. Now, this is similar to passing off, but specially involves a competitor obtaining information about new products, designs, or trademarks that another trader is preparing to launch and then launching them first to disrupt the original trader's business. This adoption or dishonest adoption of a competitor's sign or get up. Moving on, we have adaptation of a competitor's trade description. This involves using a competitor's trade description. Thus, we are no fool if the trade description has acquired a secondary meaning that makes it indicative of the original product. A distinction must be drawn between the primary description and secondary description. For example, soul fire for chicken licking, or finger licking good for Kentucky Fried Chicken are trade descriptions with secondary meanings. Now, moving on, we have Despairing comments regarding a competitor's business. Making despairing comments or invidious falsehood about competitors' business, performance, or products is unlawful. However, there is a fine line between falsehood and acceptable puffery humor. Moving on, we have interference of contractual relations. This happens and a third party's conduct prevents the contracting party from giving performance they're entitled to, or increases contracting party's obligations. Well, this is unlawful to the extent to which it leads to breach of contract. Then we have boycott of a business. This occurs when a trader launches a media campaign to boycott another business's product without any legal basis or justification. Then we have physical or psychological pressure exerted on a rival's customers or employees. This involves a competitor disturbing a trader's business operations through intimidation of employees or blocking premises. And finally, we have trading in contravention of another's right. This is when a trader gets secret confidential information from another trader and use it to gain an unfair advantage over other traders in that market. Now let's look at unlawful competition defenses. Firstly, we have self-defense. Now, a company might infringe on a competitor's goodwill in response to the competitor's own wrongful actions against them. For this defense to be valid, the response must be reasonable and not motivated by the desire to punish the competitor. The second defense is necessity or emergency. Now here, if a customer asks a trader to provide a comparative analysis between their product and their competitors, and the analysis is limited to fair comparative advertising, this could be considered a valid defense under necessity and is unlikely to be deemed unlawfully covetous. The third and final defense is public interest. Now, an infringement of a trader's right might be justified if the action is in the public's interest and the interest overweighs or outweighs the trader's rights. Now, that brings us to the end of unlawful competition. We've looked at all the common law provisions and remedies as well. On our next video, we'll be looking at a different aspect of intellectual property. Stay tuned. This is CT Education, your home for education in all forms, shapes, and sizes. Don't forget to like, share, and subscribe.